it again, and if you fail to give me a direct response, then you will forfeit your right to call any other witnesses. So I'm going to unmute you. Actually, I need to bring the jury back out. But before I do that, I will unmute you first and ask you which witness you intend to call so we can at least have that person ready to go and outside the courtroom. Who will be your next witness?
I'm not calling no witness if I got to be in this other courtroom.
Would you like to come back into this courtroom, sir?
Why was I ever removed? You never answered.
I've made a record of that, sir.
I have to answer everything, though. Everything you ask me, you expect me to answer, but then when I ask you questions, you never have to answer anything. I just put on the record that 2 of your bailiffs just made gestures. When I'm looking at them off the reflection of the screen, they're making gestures behind my head that make me feel uncomfortable. I just brought that up on the record. You didn't even address that.
Mr. Brooks, I didn't address it because, frankly, you keep interrupting me, and then I have to deal with the interruptions and make a record regarding that. So I just saw the captain walk over. I will let security personnel, Captain Dussault, look into that, and if appropriate, he can bring that conduct to my attention. I'd also remind the defendant that at any time you can also ask to be brought over through the bailiffs who are in that courtroom. So to be abundantly fair to you, I will ask one more time, would you like to come back over to this courtroom?
I should have never been removed.
That's not answering my question, sir.
You haven't answered my question.
The court's not going to answer questions directed at the court by the defendant because they're not relevant or probative at this time, and they're a delay and disruptive tactic. Mr. Brooks. They're not a delay and disruptive tactic. Is that a judicial determination that you're making? I'm going to mute you because we're going off on the judicial determinations. Every decision I make, sir, is by definition a judicial determination. It is on the record. If there is a conviction, you can raise whatever issues you want on appeal if you are convicted. But we don't need to have this back and forth every time to further make the record when the record speaks for itself. You were given plenty of opportunities throughout this trial to make offers of proof, to state your legal reasoning for either an objection or for a question that's being asked or for a whole host of other things. But right now, you're not doing anything legally relevant. You're being disruptive. I would like you to be present. That is always what I want during this case. It certainly, I think, is important, but you can forfeit your right to be present by your conduct, which you have done repeatedly throughout this case. I will advise you that if you are in that courtroom, because I have put you there and you have not reclaimed the right to be present by number one, asking and then expressing a willingness to conduct yourself consistently with decorum and respect inherent in the concepts of courts and judicial proceedings, you will remain over there. And it looks like he took his headphones off, so I will. Mr. Brooks, I'm advising you that if you fail to call a witness, you will forfeit your right to present any additional witnesses. And I'm doing this outside the presence of the jury right now for a reason. I need to know from you right now, you are unmuted, who is your next witness?
She trying to say something to me? Yeah. What you trying to say?
That was very disrespectful, sir. You chose to take off your headphones.
Yeah,
you choose
because
to
I'm
read.
muted. I'm muted. So why am I gonna have my headphones on and I'm muted?
Well, I would think your headphones help you hear. The muting is so that I don't have to hear the disruptions.
Okay, well, then why should I need to hear what
So
you
let
say?
me be clear, sir. And you
are
are
not
not.
be clear or nothing. I don't gotta listen to you.
I will ask you one last time, sir. Who is your next witness?
First of all, is she talking to me again?
He.
So
This.
we gotta keep doing this little childish stuff, dude. I gotta sit up here and I'm supposed to abide by every single rule, but don't nobody else gotta do that.
The record should
Judicial misconduct.
reflect that Mr. Brooks
Repeatedly.
is spouting off, making
I think
unsubstantiated
the record can hear me. I think
allegations
they can hear me.
against this court,
Unless I'm
directly
muted.
attacking the integrity of this court and these proceedings, while yet
This court ain't got no
refusing
integrity.
to answer
This court don't have
simple
no
questions. Mr. Brooks, you
That's
are,
not my name. I told you I don't consent to being called that name.
sir, you are hereby advised this is the last time I will ask this question,
Don't talk to
or
me
you
like
will
that.
forfeit your right to present
Can't do that.
any
Show me what-
additional
show me
witnesses.
where that's law.
Because
Show
you
me
are
where
not
that's law.
cooperating with this process.
Show me that it's law. That's all I'm asking. Show me that it's lawful law.
Mr. Brooks,
How can I forfeit not being able to have a defense? Are you kidding me?
all I'm asking is that you conduct yourself with dignity, with decorum, and with respect. I will
Okay.
gladly bring you back into this courtroom so you can present your additional witnesses.
You're
But
right.
you need to ask me to come back into this courtroom.
With all due respect, I'm tired of having this back and forth with you every day. It's not my intention to come in here and have these interactions with you every day. It's not. Regardless to what you may think, regardless to how you may feel, that is not my intention, okay? I simply do what I do because I do not have the understanding. So if I don't understand something, I'm going to ask a question. I apologize if it makes you feel that I'm intentionally trying to delay the proceedings, if I'm intentionally trying to be disruptive, because that's not the case. And I feel very, 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 very disrespected every time the record is made, making it seem like that's what I'm attempting to do. So of course it's gonna frustrate me. Of course it's gonna make me a little bit upset. And I just want you to understand that. It seems to me, the way I'm interpreting what you're doing, it is your courtroom. That's not a dispute. That's not up for debate. You control what's going on in there. That's not a dispute. But the way I'm interpreting what you're doing is that I'm being held in contempt. That's how I'm interpreting it. Because one of the three things that's cited in the Illinois versus Allen, one of them is being gagged. I haven't been gagged. One of them is held in contempt.
What's the third, Mr. Brooks? What's the third?
The third is removed from the courtroom while the trial continues, right? That's the third, right?
And that's what's been done.
Okay, so now, where does it say after that, that having me on a headset or being able to see and hear and all this and this, how is that not prejudicing my defense?
Sir, you can raise that issue on appeal. You can raise that issue on appeal if you are
This is why I say
convicted.
that. This is why I say that, though, because I can't even see. The only thing I can see right now when I'm looking at the TV is you and the prosecution table. I can't see anything else.
I understand that, sir. I'm fully aware of that.
So I'm not fully aware of what's going on in the courtroom. Don't I deserve that right to be able to see and hear everything that's going on?
If you can conduct yourself consistently with the decorum and respect inherent in the concepts of courts and judicial proceedings, the answer then is yes. So
what did I do
I'm
when
not
I'm
going to have a
just in
debate
there?
with you about the law. I will ask you again, would you like to come back into this courtroom?
Are you going to kick me out?
Sir, I'm asking the questions right now. Would you like to come back into this courtroom? Yes or no?
Are you going to kick me out?
Sir, it's a yes or no question. Would you like to come back into this?
My answer was based on the reason why I'm answering like that is because the moment I say something, it's going to get me put out. I don't want to keep hauling this stuff back and forth and back and forth and back and forth and back and forth. It makes essentially, it wastes time, really.
I'm well aware of that, sir, that it delays the
Yeah,
proceedings.
But then it's laid at my feet as if that's my attempt. You think I want to be over here?
Sir, I don't know what you want or don't want at this time. I know that we need to complete this trial and that you have frustrated today more than ever before the ability of this court to do that.
Well, I apologize for you feeling that way, but I'm frustrated too. And nobody seems to take that into account. I'm just as frustrated as everybody. Probably more.
Then I suggest that you conform your conduct to the requirements of courtesy and decorum so that you don't run the risk of forfeiting your right to be present. But that falls on you and you alone, sir.
There is no conduct that's, I don't understand what you mean by that. I really don't.
Mr. Brooks, you may not understand it. I don't think that's accurate. I think you know exactly what you're doing.
If that's what you think, that's fine. I can't argue with you.
You have
about your
demonstrated
opinion.
throughout this case that you pay attention to witnesses' testimony, that you make cogent and coherent objections at times, that you have even had evidence suppressed in this case or stricken. That's the word I used during this case. You made an opening statement. You communicate with witnesses. So
Your
you
Honor,
clearly
it's
read,
not
write,
fair.
and understand English. That's not an issue
not-
here, sir.
It's not fair
Are
to
you
say.
self-represented? Absolutely. Does that present difficulties and disadvantages? Absolutely. But that takes me back to when you waived your right to counsel. And you did so knowingly, freely, voluntarily, and with a full understanding of the disadvantages and advantages of doing so, meaning advantages of having an attorney, the disadvantages of doing it on your own, and you made a deliberate decision to
Your Honor, that's
represent
not fair.
yourself, and that comes.
He sure did, and look how well it's going for him. We're going to squeeze in a quick break, get you right back in the courtroom after this. Welcome back to Court TV Live. I'm Julie Grant. We continue following the case in Waukesha, Wisconsin that has captured the nation's attention. It is the deadly parade crash trial. And all throughout today's proceedings, we've seen interruptions and disrespectful behavior, outbursts, you name it, we've seen it from, you guessed it, defendant Darrell Brooks. Now, he's representing himself in this case, and the most recent outburst and disrespectful behavior prompted Her Honor to move him to timeout, to that other courtroom where she's got a mute button, and she can control the outbursts and speak to him until he calms down. So we were just seeing their interaction kind of winding down there, where she's telling him, I will bring you back in the courtroom as long as you promise to show the proper respect and decorum that is required in criminal court in the United States of America. So let's go back in now at the point where we left off.
To represent yourself, and that comes at a risk to you of, yes, at times not fully understanding the law, the rules of evidence, the rules of procedure, but you do so at your peril.
That's not fair to state, Your Honor, because...
So I'm going to do the following. Since I'm not really getting anywhere, I'm going to mute you for the moment. I'm not getting anywhere with him. I would like him to be brought over, and he has a choice to make. He can come back over or he doesn't. Either way, he's going to be asked to call a witness in front of the jury. I will ask him 3 times if he fails to give me a direct answer, and after the 3rd time, I will make the appropriate finding, but I will do that outside the presence of the jury. But we are going to continue. So we'll go off the record and he will come back over here. Thank you. We are in recess until that happens.